Welcome back to the fourth and last part of this video lecture. In this part, I will talk about challenges of legal cooperation with a view to prisoner transfers. The focus again will be on Germany and the Netherlands, but keep in mind that most of these issues I'll address can be easily applied to other EU member states and other fields of legal cooperation. At the end, I will reflect on the role of EU policies within legal cooperation and specifically how the principle of mutual trust and recognition impact the daily work of legal practitioners. But first, let us look at the sentencing systems of both countries. It was already mentioned that Germany tends to be more punitive than the Netherlands. This is reflected in the length of sentences, but also in the relative size of prison populations. While Germany and the Netherlands share very similar legal cultures, such as the three-tier court structure, the stages of appeal in criminal cases, the prosecution monopoly of the public prosecutor's office, and the inquisitorial criminal justice system, there are also some differences. The Dutch criminal justice system tends to be much more pragmatic than the German and is in that respect closer to the common law systems of the UK or the USA. Dutch criminal law is less dogmatically driven and less formalistic than its German counterpart, a fact that is also reflected in jurisprudence, where a just and workable solution to a problem at hand is often considered more important than systematic coherency. The opposite is the case in Germany, where jurisprudence is guided by systemic thinking, internal consistency, comprehensiveness of the law, resulting in a tendency towards a certain formalism. But how does this play out in legal practice, and especially in legal cooperation when it comes to sentencing? Let's have a look at two examples that demonstrate the challenges. First, when looking at prison statistics, one can see that Dutch courts tend to put more people into prison for a shorter time. Dutch courts justify the avoidance of long prison sentences because of their alleged desocializing effect and rely on short imprisonment for a wide range of offenders. In Germany, however, short prison sentences, meaning those of less than 6 months imprisonment, are pursuant to paragraph 47 of the Criminal Code supposed to be the exception. Interestingly, the reasoning is similar as in the Netherlands, but the conclusions are the opposite. Short prison sentences are considered to be ineffective since the deterrent effect is limited and the negative consequences, such as the loss of jobs, the weakening of family ties, criminal contagion by socializing with other criminals, the costs of reintegration into society, and the risk of prison overcrowding, are considered to outweigh the benefits. This is a legal cultural difference. German courts are more likely to give longer sentences, but these are often suspended to avoid prison stays that only last for a couple of months. Besides formal legal reasons, one reason is that German prisons are less prepared for reintegration than Dutch prisons are. This means that certain educational or vocational offers are limited and only available for prisoners with longer prison stays. Now, this poses a dilemma for German prosecutors in cases where a Dutch court sentences, for example, a German citizen to a few months imprisonment and to transfer him back to Germany. How to deal with these cases? Remember, the rule is that the sentence of the issuing state has to be executed in full. However, it does allow to apply national probational rules. With that in mind, the problem goes the other way as well. For example, Belgium has the rule that a prison sentence is suspended after half the time has been served. Moreover, due to overcrowding in prisons, many prison sentences under 3 years are served at home wearing an electronic monitoring device. In Germany and the Netherlands, a probation is in most cases only applicable after 2/3 of the sentence has been served. This means that a Belgian citizen that is sentenced by a German court to 3 years in prison may be transferred back home and actually never see a prison from the inside. To avoid this form of impunity, German courts may get the idea to give a longer sentence than a German citizen would have gotten for the same crime, or to refuse a transfer from the beginning. This, in turn, may have a negative impact on the rehabilitation opportunities of the person. Another crucial difference between the Dutch and the German penal system is the role community service plays as a sentence. In the Netherlands, community service, the so-called taakstraf, is a main sentence according to Article 22c of the Criminal Code, with a maximum duration of 240 hours. Remember, in criminal law, different forms of punishment exist. A main penalty is in Germany a custodial sentence and a financial penalty. Probation is always a custodial sentence that is suspended, meaning that is always connected to a custodial sentence. In the Netherlands, there exist more main sentences, such as community service. The latter can be suspended as well as being combined with a fine or, in exceptional cases, even with imprisonment. The courts are free to determine what type of work the convicted person has to perform, and in cases of lacking compliancy, the sentence can be converted into a prison sentence. Community service is a popular sentence in the Netherlands and is more often imposed than a custodial sentence. But this popularity of community service as an alternative to imprisonment is not undisputed. In terms of legal policy, it came under considerable pressure at the beginning of the 1990s, where it became public that community service had allegedly been imposed for serious offenses such as manslaughter and even murder. Although these allegations were not confirmed in a subsequent investigation, the acceptance of the work penalty among the population suffered. Under German criminal law, community service is very rarely imposed. The reasons for that, once again, are based on doctrinal or formal considerations. Pursuant to paragraph 38 of the German Criminal Code, community service is not a main sentence with the exception for juvenile criminal law, but can only be imposed as a condition within a probationary sentence, so-called Bewährungsauflage. This again poses a problem to German prosecutors. What if a German citizen, maybe an exchange student like Hans from our case study, is sentenced to community service in the Netherlands, but wants to serve his sentence back home in Germany? German authorities may have no capacities to make this possible. Sure, one might find a place where the convicted may work for the community, but this work has to be also monitored. What if the convicted suddenly doesn't show up anymore? What happens if he refuses to do the work? When a convict does not comply with his probation conditions, the underlying custodial sentence is reinstated. The convict failed to comply with the last warning and goes to prison. But what happens in cases of community service where no underlying custodial sentence exists? These are all practical and bureaucratic problems, and the result is often that German authorities would rather decline the request of a transfer than to change their ways to make it possible. In consequence, our person would have to serve his community service in the Netherlands, or, and that is the worst case scenario, Dutch judges would anticipate this problem and, for reasons of simplicity, sentence the student to a prison sentence to avoid the risk of transferring a sentence that realistically won't be executed in Germany. In that case, his sentence is aggravated from community service to prison time, which is against the legal principle of reformatio in peius, which stipulates that if you appeal a certain decision, the outcome cannot become worse than before. It's considered one of the main challenges for the future to establish guidelines to adjust and convert alternative sanctions into equivalent measures within the EU penal systems. Now, these are only two examples of legal differences between two member states that may seem minor from the outside, but makes the transfer system difficult to implement for practitioners and is a constant source of frustration. Even more importantly, it may negatively impact social rehabilitation prospects of the sentenced person. Here lies one explanation for the fact that despite large numbers of EU foreigners in German and Dutch prisons, and despite the fact that most prosecutors may consider the transfer system a good idea, the number of conducted transfers is surprisingly low. Remains the question what the EU is doing against these problems. Keep in mind, the framework decision concerning the transfer of prisoners are based on an EU initiative. Did they not take into account these legal and cultural differences between the member states, or did they just don't care? What is the underlying, let's call it, political ratio behind these EU initiatives? To get a better understanding, one has to look at one of the guiding principles of the EU justice area, the principle of mutual recognition, the cornerstone, if you want, of the common judicial area, which forms the basis for our framework decisions. Article 67 paragraph 3 in the Treaty on the Functioning of the European Union stipulates that a high degree of security is to be ensured through the mutual recognition of criminal decisions. Although not explicitly mentioned in the treaty, the principle of mutual recognition is generally assigned to the far more abstract principle of mutual trust, or is considered to be a consequence of it. Mutual recognition presupposes trust in the legality and legitimacy of a member state's decision. Now, what does this mean for the transfer system? Well, a number of things. First of all, and as already mentioned, the underlying judgment that is the basis for the transfer is considered to be legitimate. A legal revision of the prison sentence is not intended. If you think about this, it seems rather odd. A member state executes a sentence, which means it interferes with the human rights of an individual, often one of its own citizens, to the maximum possible extent. And this without having much of an idea of what the sentence was based on, which reasoning played a role. The only basis is trust in the judiciary of the other member state that has issued the sentence. On the other hand, also think of the issuing state, the one that transfers a person to another member state for execution. In many cases, the authorities may have no influence on the conditions under which the sentence is executed. In many cases, authorities have no specific idea about prison conditions if the special needs of a prisoner are met in the executing state. In view of bad prison conditions, transfers can then constitute a violation of the provision of torture codified in Article 3 ECHR or Article 4 of the EU Charter for Fundamental Rights. If you take all these unresolved problems into account, it doesn't seem to come as a surprise that member states are still rather reluctant to transfer prisoners, at least when certain member states are involved. These reservations result in some sort of discrepancy between a legal and an empirical reality. Trust in other EU national legal systems may be a precondition, but it is rarely felt and lived by the actors. This trust would require compatibility of the criminal legal systems. Only if legal practitioners can trust that the same rules apply at all stages of the criminal justice system, if they can trust that the same high human rights standards are applied in all member states, then this trust would follow automatically. Consequently, harmonization of sentencing should be looked upon as a sort of a last stage harmonization. Now think about this for a moment. Wouldn't it make much more sense if the EU would first put all their efforts into harmonizing the criminal legal system of all member states, including the sentencing systems, and take care that the same standards are applicable everywhere, and only then implement a transfer system for prisoners? Wouldn't that be the more logical orders, if you want? Of course, the reason the EU cannot follow this logical order is that the harmonization of national sentencing systems would require amendments to the EU treaties. Simply put, the European Union has no competency to change the criminal legal system of its member states. Then change the treaties, you may argue. After all, there are a number of legal fields that have been heavily influenced by EU law. But of course, it's not that easy. I've already elaborated on it. There is hardly any part of the law that is so heavily influenced by legal culture and legal traditions as criminal law, and more so sentencing. Even if the member states were willing to harmonize sentencing, should the EU take over the lenient sentencing of the Netherlands? Or should it take over let's say, the tougher sentencing regimes of Germany or some Eastern European countries? Instead, the EU chose a different path by allowing for transfers despite the penal system being so diverse, and this unfolded a dynamic that can be described as nudging the member states to adjust their systems to each other. In the long run, harmonization is introduced through the back door by necessity, since the sentencing practices between member states simply require standardized and harmonized system. Now, in that sense, the EU opted for an approach which can be observed in other fields as well, and is visually best described as putting the cart before the horse. With that, I conclude, and I thank you for your interest. If you have questions, don't hesitate to send me an email, and I wish you all a very good day.